All right, good afternoon, everybody. Thank you so much for joining here on the Protect Your Estate webinar. I'm Jeremy Wechsler. I'm an estate planning attorney. I'm going to take you through here the next hour to talk about your estate planning, and everything you need to know in that regard. So again, thanks for being here. If you have any questions today, please use our chat option. So to find the chat option, you basically will hover over with your mouse or yeah, probably your mouse at the bottom of the screen. So if you're on a computer, it should be at the bottom of the screen and you'll see a chat icon and you can click that. You also, if you're on a mobile device, a bar should appear at the bottom with the chat option as well, so you can click that. If you're having trouble hearing, please check that your volume is turned all the way up. And finally, in the chat option and also in an email, we're going to give you a link to our my calendar, and also a copy of the presentation and a couple other later supplements later today. So check your email later for that, and also the chat so you can schedule a brief call with me or a longer meeting, whatever you prefer. So there's a couple tips. Again, any questions you've got, please ask them at any time throughout the presentation, and I will save some time at the end. So you can put them in any time. So if you have a question while we're talking about a certain topic, please pop it in the chat. And again, I will get to it. Keep the questions, if you can, please, general in nature. So if there's something more personal or something more involved, that's better for a one-on-one discussion. All right. So a little about me. I've been practicing in estate planning and law for about 15, 16 years. And I've got a certificate in estate planning from Temple University in addition to my law degree. And I'm licensed to practice law in Pennsylvania and New Jersey. I've worked at a firm in Bucks County for a few years. I am on my own now as a practitioner here in Horsham, and we also have an office in Center Valley. I'm also an investment advisor licensed in Pennsylvania and actually across the country, and also insurance licensed as well. So that's a little bit about me. A lot of what we'll talk about today is in regards to estate planning, but I will talk about holistic planning at the end and how all the puzzle pieces really need to fit together. So when we're planning, it's really tough to make predictions about the future, as Yogi Berra said, and we have to do our best. We can't just sit on our hands and hope for the best. We have to do planning, even when it's difficult. As tough as it may be, you really want to sit down and plan and then go back a few times during the course of your life, as often as you need to revise the plan, to retool the plan. It's not a one or done thing. So I'm packing a lot of information in today's webinar. So first, we're going to talk about the threats to your estate. Unfortunately, there are a lot of them. I'm going to jump into the fundamentals of planning. So all of the documents and type of tools you need to know about, things that you may or may not need, things you might have heard about and question whether you need them. Then I'm going to go into some key information. There's a whole lot in here, talking about what probate is, talking about inheritance taxes, talking about the title of different assets and how important that all is. So I'm going to get into all of that. I will top it off with holistic planning at the end and kind of tying this all together. Okay, so that's our roadmap for the next hour. Again, questions, please feel free to pop them in the chat. It should be at the bottom of your screen. So what are some threats to our estates? There are a lot of them. I picked a few that I get a lot of questions about and a lot of concerns about, and I've seen a lot of mistakes made. So the first one is taxes. And the question that I always ask in my mind is what we're doing tax efficient or not? Okay, because there are some things that we can do that may make sense or may seem convenient, but they don't make a lot of tax sense. And a lot of the states have a hidden tax bomb. It's really that is our 401k that we've been contributing to, and we've saved and a good job of trying to maximize that where possible, getting the employee match. But that's a tax bomb that's waiting for you and your heirs later. And a lot of us also don't look at other smart tax strategies or tax favored strategies. So really, when you think about what do the smartest people do, they're going to make logical decisions. So for instance, I'm in the next slide, I'm going to talk about life insurance. People may say to me, I hate life insurance. I don't even want to talk about it. But life insurance actually makes so much sense when you think about a tax efficient plan. So hey, you might have said before, I really, really do not want to consider life insurance, but now might be the time. Okay, so there are a bunch of taxes here that we have to deal with. We have inheritance tax in Pennsylvania and a couple other states, not many, but in Pennsylvania, we've got it. We've got a federal estate tax, we've got capital gains taxes, and then we've got income tax. So there's a lot of different layers here when it comes to your estate that you've got to be aware of. And different assets will be taxed different ways. And depending on how much you have, in your estate upon your death, there may or may not be an estate tax, for instance. And I'll talk about some updates to the law that just passed, actually, throughout this presentation, the big, beautiful bill. All right, we'll talk about a couple pieces in here in regards to that. All right, so as I said, I teased this a little bit. I said life insurance is a very tax efficient vehicle to pass money on, to pass assets on to your heirs. It's inheritance tax free in Pennsylvania. It's income tax free, and it also can be federal estate tax free. So again, if you're not considering life insurance or you wrote it off because of something you heard years ago or somebody on TV told you don't consider it, you may want to rethink that. It may fit into your plan. It can also pair with long-term care insurance. They kind of sit side by side with one another with certain types of policies. And I'll talk about long-term care in a moment. But life insurance can be an excellent tool to pass property on. One term we use is arbitrage, arbitraging your estate, taking a little bit and making it a lot bigger. So if you want to leave an estate that's tax-free to your heirs, this is a great option. What about your 401ks? A lot of people consider converting to a Roth IRA, but a lot of people don't consider converting, and you really should. And also, if you're still working and you're under a certain income threshold, you should really consider contributing to a Roth 401k, or if you're maxed out, to a Roth IRA. And again, there's different rules around these where you're cut off at some point from contributing, but you can always do what we call a backdoor Roth. These are different things that I can discuss with you. What happens with Roths, why are they so great, is that, well, when you put the money in or when you convert, you're paying the tax then. But when you withdraw later, when you distribute later for yourself or your heirs, there's no taxes. And look, these accounts are going to grow. They're in the market. So if $500,000 today, 20 years from now, could be worth $2 million, depending on how the market goes, depending on how your investment performance is. And your partner there, Uncle Sam, is just going to keep collecting. Wouldn't it be nice if you kind of froze that IRA, that 401k, so that when you withdrew, it's 500,000 that you pay taxes on, not 2 million that you'll pay taxes on. So again, these are things that you really ought to consider when it comes to your estate that are smart tax strategies. And when you don't do them, it can often trip up your expectations and your heirs' expectations. Gifting, another great strategy of a lot of gifting power. You can gift $19,000 per person per year. That's a lot of gifting power, depending if you have kids, grandkids, or other heirs. So these are great ways to reduce the size of your estate that you're leaving and therefore reduce the tax burden and also give people what they need right now versus waiting until you die. We hope you live a long time, and so do your heirs for the most part, but they may need something now, and it may be a smart tax strategy to give that to them now. And finally, charitable giving. There's lots of stuff to uncover in charitable giving, whether you do it now, whether you do it as part of your estate plan. There's good ways to do it. There's not so good ways to do it. But bottom line is charitable giving can, again, really mean tax advantages. It's not just that little write-off that you may get on your 1040 on your income taxes, there's a lot more that you can do with charitable giving depending on how charitably inclined you are and how large your estate is. So if you are charitably inclined and you're also worried about minimizing taxes at death, then this is something that we really ought to look into seriously. So those are some tax strategies that I've teased for you. I want to talk about another threat, which is long-term care. And I say long-term care, which is unfortunately we're getting older. We might need a nursing home. We might need home health care, assisted living, whatever it is. This all costs a lot of money, and long-term care planning is so connected to estate planning. And I find that a lot of folks that I meet and talk to do not take long-term care planning seriously. They do not address it at all. And that's a concern because there really are three options. And that first bullet point that I wrote is not an option, that you hope you don't need long-term care. Folks, as we get older, there's more and more of a chance that you will need long-term care. The odds get greater and greater. So there's options to either pre-plan, which is do things while you're healthy, or do crisis planning when you go in to the nursing home. There are options that you can do and take advantage of, or really your family at that point, because you'll probably be incapacitated and unable to do the planning yourself. But there are things that you can do upon entering a nursing home to save some money. If you're very wealthy, if you're a high net worth individual or family, chances are you may be able to just privately pay or self-fund your care without worrying about running out of money and trying to get on the government's plan, what we call Medicaid. But by far the best thing that middle-class families can do is try to look at what options are available while you're still healthy, whether it's use of insurance, whether it's use of trust, gifting. There's different things you can do, but you got to do the pre-planning while you're healthy. You don't want to wait till you're 80 years old and not in such good health. So we're talking early to mid 60s, maybe late 60s is a good time for pre-planning. Yes, even for insurance. For sure, some of us are not healthy enough to get insurance. I get that. But for those that are, it's a good option to look into. With long-term care, middle-class families are the ones that are most at risk, unfortunately. It really is the number one concern that folks are dealing with in retirement, yet it's most commonly unaddressed. So it's a concern, but nobody's doing anything about it. That's not great. There are things you can do with insurance. So there are insurance options. There's traditional long-term care insurance, which kind of has gone by the wayside. We don't see too many of those policies anymore, but there are certain other new policies that provide flexibility with return on the premium that you pay if you never need long-term care. There's life insurance options that pair with long-term care so that if you need long-term care, you can use the death benefit or most of it towards your care. So there's different options out there that if you're looking at insurance, you'll find, like if you look 10 years ago versus today, there are a lot of new options out there. And then we talked about, I teased trust planning. There are certain types of trust you can do depending on the assets you have to protect a portion of your estate later on from needing to be spent down. These are, again, smart ways to get the government to pay for your nursing home sooner. So your nursing home bill through what we call Medicaid. Not Medicare. Medicare is what we all get when we reach retirement, when we reach 65. Medicare is not going to pay for your long-term care. It'll pay for a little short-term rehab, but it will not pay for your long-term care. Medicaid is what covers long-term care when you run out of money. Now, there's the new big, beautiful bill that changed Medicaid. If you've been reading the news, you've seen that there have been cuts to Medicaid. I do not think there will be a lot of cuts or changes with the long-term care aspect of Medicaid, but there might be. There might be certain providers that don't accept Medicaid out initially in Pennsylvania and other states. Once you're in a nursing home and you run out of money, the nursing home has to accept Medicaid, but they don't have to accept it on the outset. So you may see some changes in certain nursing homes that do not accept it at the outset. So I always tell clients, like, because we have clients that mostly have money, that you don't want to spend all your money down. You don't want to gift all your money. You want to have money to pay for your care for at least a year or two so that you can get into the better places. One change that this new law uh, has in it is that renewals for Medicaid, so you have to renew it every year. Now it's going to be every half a year or so, 6 months will be the renewal date. So you've got to prove income and assets and eligibility every 6 months versus a year. So it can make it more onerous at this point. We'll see how that all plays out. So that's long-term care. And I want to hit family dynamics here briefly. Um, we talked about threats. We're in this category, threats to our state. What's a threat to our state? It's the family disputes. It's the kids not talking to one another, or they're suspicious of one another, or they haven't got along for a while, and now this estate is kind of vague. The planning was not done correctly, it was not done well, it was done a long time ago, and people are interpreting it differently. Not great. So your estate is most at risk of failing and being in court when you've got family disputes that you don't address and you don't do the proper planning. And unfortunately, in my practice, I would get a lot of calls from folks that the kids called me and the parent was in the hospital and the kids were saying, Mom, Dad needs to do planning. What do we do now? It's too late. Okay, because really the only time to do planning is when you have the freedom of thought, the competency, the lack of somebody influencing you and telling you what to do and talking for you. This is not good planning. So you want to do the planning now while all is well. You don't want to wait until you're in the hospital or something goes wrong to start thinking about estate planning. That's number one. And number two, when you do the planning, talk to your family about the planning. Don't assume that they're going to understand or appreciate what you've done. Let them ask questions, even if they're uncomfortable questions. And you don't have to tell them every dollar you've got or what accounts you have, but talk to them generally about what you did. I named this person as executor over this person because of this reason. Okay. And these are easy ways to stamp out any potential issues. And yeah, somebody may not be happy that they're not the executor, even though you're probably doing them a favor, but at least they're not asking that after you're gone. This is not something that you want to toy with or play with because we're talking about your legacy here, and your legacy matters so much. And you want to leave a positive legacy. You know, that last or that first meeting after you're no longer here of your family, how's that going to go? Kind of picture that in your head. Is it going to be smooth or is it going to be a bumpy ride? And if it's going to be a bumpy ride right now, are there things you can do to make it less bumpy? All right. So these are really, really important pieces. And it just speaks to getting this done sooner. So when I say, hey, get on a call with me or get on my calendar, I'm doing it really because I know that, well, first of all, I'm not pressuring you, but I know that we procrastinate and I know we hear this today and we forget about it tomorrow. And you don't want to forget about it. You don't want to let this kind of go on another few years and hope for the best. Okay. Another threat is our loved ones, our beneficiaries, whether they're our kids, our nieces, nephews, grandkids, friends, whoever it may be that you're including in your estate. Look at all of these categories here that we have that I have concerns about, and there's more. There, I could add a whole page, but these are a few big ones here that when you're leaving property to these categories of folks, you really have to be careful about how you leave them the property. You don't want to necessarily leave it to them outright. You may want to consider the use of a trust so that they get their property in a trust rather than a check and they have unfettered access to it. Minors, grandchildren, people that are spendthrifts that have a dollar, spend a dollar, people with addictions, disabilities. And disabilities is a special category. There are certain rules around if you're receiving public benefits that that person cannot receive a direct inheritance. So there's a way to use a trust, usually what we do is a supplemental or special needs trust for those individuals so that they can have the benefit of certain supplemental needs being paid for by the trust and still not preventing them from getting those public benefits like Medicaid or SSI. Another category, people with high risk professions, people that have rocky marriages, those that are easily influenced. And by the way, disabilities can, it's a gray area. There are some folks that are 100% disabled, but there's a lot of folks that I've encountered in my years of practice where the kid might work in the grocery store, but they would be very easily influenced. You can kind of pair those two categories together. So although they're not getting benefits, they would not be a person that you want to leave money to directly. So anybody in these categories, you really need to pay special attention to in terms of making sure that there's a proper trust in place for them. I've seen too many cases on the other side where there's somebody has died and there's administration that the person that died didn't set up something for somebody with an addiction. I've seen that a few times, unfortunately, and the family asked me, "What can we do?" And there's the benefit that the options are few and far between unless that person cooperates, which oftentimes they're not going to cooperate. So the person that's passing the money, you have to do this now. Okay. Finally, the last threat is the danger of doing it yourself. And I wrote about this a little bit in the Franklin Retirement Solutions newsletter. That's our investment advising and retirement planning firm. I wrote about this last week, and I talked about how I I am prone to wanting to do things myself also. And I'm of the internet generation. I would love to just hop on and solve it myself and solve it very quickly. But estate planning is much more than typing in a few words to a computer and pumping out a will. You're probably going to miss a lot of pieces of your puzzle, besides the tax planning, besides long-term care and healthcare planning, besides the fact that you've got all these different accounts out there that already have beneficiaries designated and yeah, you're probably making a mess of things. And then coordinating with your retirement plan. All of these pieces show you that and illustrate that doing it yourself has a lot of limitations, and you're not getting the full view of what you can do or what you should be doing. And worse, you may be making real mistakes. And once you're gone, we can't fix that. All right. I've seen that where we've got a poorly written document, whether it's a will, whether it's a power of attorney, whether it's a trust, and it's somebody that maybe kind of did it themselves and not good at all. I looked at a friend's documents a couple weeks ago, right before the holiday. He had sent them over to me. Unfortunately, he's got a health matter. And after all these years of knowing that I do this stuff, he's still trying to do it himself. And I took one look at it. I said, forget this. This is terrible. The way you've set things up makes it so ambiguous. I can't even get into some of the mistakes I saw there, but bottom line is easy to clean up. It wasn't a complex matter, but the last thing we want to do is take a matter that's not that complex, try to do things ourselves and make it complex and make it difficult. So just think about that when you're doing it yourself, or have you done it yourself before? Don't do it. All right. Get some help, get some professional help, get somebody who has the experience to walk you through doing the documents correctly, but then also looking at the bigger picture. Does everything fit together? Do all the puzzle pieces fit together? All right. So those were some threats. There's a lot more, but I've only got an hour. So we're going to do our best here. I've talked about some fundamentals of estate planning, and first question we ask is, what is estate planning? Estate planning, some people think about as just my will. Other people think about as financial planning. Other people think about as trusts. But estate planning, as you can kind of tell, is it's a lot of things. So how do we break it down is kind of the way I thought of this here is, first of all, estate planning is who controls what, and you're going to decide who gets what from your estate and when, and you're going to try to avoid unwanted outcomes. We're going to try to protect your estate, preserve your estate. So we're talking about unnecessary taxes, fees, creditors, dealing with long-term care, your legacy. This is the family dynamics issue, and just make sure that you handle the planning in the most tax efficient and logical and smart manner as possible, so that you leave a positive legacy. And also, that gets back to long-term care planning. When you don't do long-term care planning and you're burdening your family with taking care of you, and figuring that all out. That's not a great legacy either. I mean, it happens, but are there better ways to handle it? And finally, estate planning, to me, it fits in with or kind of absorbs the tax planning, the retirement planning, investment planning, the healthcare planning. So estate planning kind of sits, in my eyes, on top of all of that, and all of those other items are part of the estate planning, or it's a piece of the puzzle as well. But either way, these all connect to one another. And so to me, that's really what estate planning is. It's kind of looking at all of these puzzle pieces and making sure it all works for your particular needs, for your particular family. All right. So, what are some fundamentals, though, with the actual documents and different tools that we may use? Sure, you're going to have a last will and testament. I sure hope you do, because you've got to express what's going to happen with your estate upon your death. Now, if you skip down to the fourth bullet point, let me just get my annotation here if I can. Here we go. So, okay. Don't know if it's going to work, but we'll try. But if not, basically the fourth bullet point, beneficiary designations, a lot of accounts, you've got beneficiaries already on that account through a contract with that company. And so they may bypass your will. These are going to supersede the will, but yet you still want that last will and testament. Absolutely. Even if you said, well, most of my accounts already have beneficiaries or they're joint, it doesn't matter. You still want the will. And everybody needs to have the next two, the healthcare directive and the durable power of attorney, or sometimes a financial and general power of attorney. These documents allow somebody to take care of you both for health and finances when you're incapacitated, when you're disabled, whether it's short term or long term. So you really need both. And finally, that last bullet point, the trust. A trust, I talked about trust a few times. I mentioned a couple slides ago with beneficiaries putting their assets into a trust. I mentioned with long-term care planning, you may use a certain type of trust to protect assets. Different types of trusts, depending on your needs. A lot of the trusts we talk about are what we call revocable trust or revocable living trust, or just living trust. These are all mean the same thing. They basically allow you to control assets while you're living and then avoid probate with those assets upon your death. But it's not all it's cracked up to be, and I'll talk about why in a couple of minutes here. But first, before I do that, I just want to reemphasize powers of attorney. So I talked about the healthcare directive and the durable power of attorney. If you don't have a power of attorney, a few things are going to happen. First of all, who's going to make decisions for you? That's going to be up to a court. And somebody has to go petition for guardianship or conservatorship over you. And that's expensive. We don't know who the judge will decide to appoint. It means that you have no control over what happens with who's going to be involved. And also, your legal rights are taken away when there's guardianship. So this is really something you want to avoid. Also, I've just seen folks that don't have a power of attorney. Let's say they need long-term care, they're in a nursing home, and they can no longer do things for themselves. What are we doing? How are we doing that crisis planning where we can save some money? Well, uh, it's going to be difficult because, first of all, getting guardianship isn't simple. And even when you get it, there's more limitations with the guardianship than when you have that power of attorney. The power of attorney is easy. You get to appoint who you want to manage your affairs. Why wouldn't you do this? So make sure, if you don't learn anything else from today, that you go out and get that power of attorney. So that I would just, if I could put like bells and whistles around this slide, I would do that. All right. This is really important. Back to trust. So again, I said living trust or revocable living trust. That's what we're talking about in this slide. And I said they can avoid probate in certain states, but I said it's not all it's cracked up to be. especially in PA or Jersey, which is where we're at here, because probate, avoiding it here doesn't mean much. I'll have a slide, and if you're having trouble seeing the next slide, I think it's the next slide, but if you're having trouble seeing that, you'll get an email with all the slides and you'll be able to look closer at it, but it kind of compares a will versus a trust. But a trust does make sense to do for your estate planning when you've got property in multiple states. So let's say you've got a property, you live here, but you've also got property in Florida. You might want to avoid probate, especially in Florida, because that process is quite different than it is up here. It's more onerous. If you want to protect certain beneficiaries, and you have a kind of other complexities, then you may want to create a living trust with trust built in under it. If you have a very large estate where you're hitting or exceeding the federal estate tax exemption. Right now, it's very high. A trust starts to make sense. If you have particular privacy concerns, so let's say you're an official, let's say you're a celebrity, let's say you have other unique concerns, a trust could give you some more privacy. I'm kind of in the middle on that. I think that sometimes it does, sometimes it doesn't. So I wouldn't say there's 100% assurance of privacy just because you have a trust. And then finally, if you've got a blended family, I was talking to a friend about this yesterday, where there could be a blended marriage in that family, and there are some complexities with that. Setting up a trust could be useful so that basically, if you were to die first, you can provide for your spouse as long as he or she is living, but that spouse can't control the trust or withdraw everything from the trust. And that way, your kids from your first marriage will still benefit from that trust. So there's different trusts out there that will help with different situations. It depends on the case and depends how long you might have been married, particularly the second or third marriage. Some I've seen some marriages that I've gotten clients, they're a year out. Others, they've been remarried for 30 plus years and they kind of look at it as a first marriage. So it really depends on kind of how you see yourself and your family. So here's that slide I was telling you about that may be a little difficult to see, but this is a comparison between having a will or having a living trust, because I often hear questions about what do I need and does this make sense or not? In Pennsylvania, as I said, a living trust in and of itself is not really great. It doesn't really do much for you because first of all, there's still inheritance tax in Pennsylvania, and you don't want to distribute assets until we know that's paid and been approved by the state, and that takes a while. So people say, well, with the trust, you'll get stuff so quickly. Well, in Pennsylvania, not really, because the trustee really has to wait for the tax to clear, and that can take quite a bit. Other big thing is that creditor protection upon death, that's the second point. The creditor protection upon death, you do not get protection, with a will. There's a year for creditors to come forward. And that's also the case with a living trust. The creditors to your estate can also look into your living trust, and they also have that year to come forward. So again, as a trustee, you're not distributing assets until you know there's no more creditors. So a living trust doesn't help in terms of getting assets to beneficiaries much quicker. There's still inheritance tax. It's more complex. Does it avoid probate? Yes, for property that's in there, but probate's not a big deal in Pennsylvania. Probate in Pennsylvania has been made informal, so we don't have to go through courts unless there's a dispute. Even with some disputes, it's done within a county office. It's not even done in the court. So probate avoidance, not such a great deal, not really a necessity at all in Pennsylvania or New Jersey. Again, federal estate tax, I did put in red here that a trust can help with minimization strategies for federal estate tax, but the exemption right now is very high. With the new beautiful bill, big beautiful bill, the exemption will be $15 million per person and will increase every year based on the inflationary numbers. A trust is more complex and it may not get you much, so keep that in mind, okay? So is a living trust for you? That's the question. Do I need a trust? The answer is you may need a trust. You may need a trust as part of your will for your beneficiary. So what they get goes into a trust. You may need a special needs trust for a disabled beneficiary. You may do the Medicaid trust that I was talking about that kind of parks assets kind of away from everybody. There's different trusts out there, but do you need a living trust? Do you need to avoid probate? Again, if you're a PA resident, all your property's in PA and you have no particular complexities and you're not over that estate tax exemption, there's no need to avoid probate. The best thing you can do is A, look at smart tax strategies that we've talked about earlier in the presentation, and B, get organized. And I have another slide in the next section on this, but the more organized you are with your estate, where the documents are, where the assets are, the easier and more straightforward it will be for your heirs to kind of get things moving and get things done as quickly as possible. Probate process itself isn't the problem. The problem is the lack of organization and perhaps family dynamics as well if you haven't solved that problem. So before we go on to the next section, as I said, a lot of us procrastinate when it comes to estate planning. And I always say that, and I get it. I mean, I procrastinated on plenty of things in my life, so I'm guilty of it too. But as much as I can implore you to take care of this, if you haven't already, I will. Or if you've taken care of it, but it's been more than 5 or 10 years, it's really time to take another look at it. So if you want to ask me questions, but you don't want to feel obligated to kind of do a long meeting or come in. At the end of today's webinar, there's going to be in the chat a link to my calendar, and there's options for a 15-minute call or a full meeting, whether it's in person or Zoom. So you have different options. But if you just want to chat with me for 15 minutes, kind of take my temperature, see what's going on with your plan, check in and see if things are what you think they should be and you think you're okay or not. Great. I love it. Schedule that time with me. We'll get you on the calendar. There's no obligation. Okay. All right. So here we go. This is an action, a full section here, key estate planning information and tips and lots of useful stuff that you can take away. Some of it's a little dense, but it's all important. One thing I talk to clients about is the title of your property. Why does this matter? Because when your title of your house, of your bank accounts, of your retirement accounts, of your checking account are a certain way, it'll affect whether or not it goes through your will. It'll affect how it's taxed, how much it's taxed. So you really can't do good, solid estate planning until you know how your property is titled. And a lot of times when I'm working with clients, we're going to look at the title again and retitle assets, maybe change how things are done. So you've got a few different titles here. You've got separate property, which is just assets in your name alone, period. So Jeremy owns a house, period. You've got separate property, but you've got a beneficiary designation. Sometimes that's known as a TOD or POD, payable on death. That means Jeremy owns this account, but upon my death, I give it to all 20 of you that are listening out here, 5% each. How generous of me, right? So that's a beneficiary designation. I own it. I control it until my death. Then it automatically goes to you. You all can make a claim on that account. Joint property. That means I own the property with somebody else. Joint with survivorship is the most common. That means that I own it with another person. And when I die, my share goes directly to them, period. It does not go through my will. But if I own property jointly as tenants in common, then we each own 50% of the property, and my 50% upon my death will go through my will follow my will instructions. So if I own property with my brother, let's say, when I die, and let's say I have 10 kids and I leave all 10 kids 10% each in my will, my brother will then have to share that property. Let's say it's a rental property now with 10 other people that have a say in it. Is that great? Probably not. Finally, joint property, the third way to own it is tenants by the entireties. That is simply a designation for married couples. And that's the same as survivorship, but it comes with a couple of extra benefits like asset protection. So if you ever see TBE or tenants by the entireties, that is specifically for married couples. And finally, you can have property titled in a trust. And again, when you do have property in a trust, the trust instructions will control. So some stuff will supersede your wills, some stuff will be part of your wills. You have to understand the flow of your assets. And I've seen plenty of clients that have a variety of flows. They have some accounts with beneficiaries designated, some separate property, some joint property, some property in a trust. It gets really confusing. And we need to know first, where are we starting from? Because if you don't know, then any plan we do or put in place isn't going to be such a great plan. It could actually backfire. So title is really important. And we may need to fix some titling. Maybe you thought something was titled one way, but it really isn't. And we want to fix it. So all very important and something to explore. And again, when you're doing it yourself, you're not going to be looking at these things. And that's where I see a lot of mistakes is, okay, well, I did this will, I'm fine. That's all I need to do. But meanwhile, your will says one thing, but all your property is titled a certain way that is doing something else. Not great. I talked about probate earlier, and I said probate in itself is not the problem. It's the lack of organization in the estate planning itself. So a few kind of tips here in regards to those documents. First of all, 5 to 10 years is your review marker, or sooner if there's a major life change. Don't do a will one time and never revisit it again. Second of all, you want to make sure that when you do the will, when you do the power of attorneys, that they're in a place that somebody can access easily, and that person being your executor, or that person being your power of attorney, that they know where these documents are, they can find them easily. I recommend a fireproof box at home. That is really the best way to ensure you know where the documents are and they know where they are. And I will tell you, I just keep documents in mind, so I don't lock it. It's just a way to make sure that I always know where that is, and the people I've chosen as executor or power of attorney know where they're stored also. I don't recommend that you give copies out of the documents. That can get confusing, and usually the executor, the power of attorney will need at least access to the original at some point. So they should have access to the original and a copy all at once, and the latest one only. Get rid of the old stuff, keep the new stuff. Again, don't give copies. Show them where these documents are so they can get to them. If you give copies, but then update it 2 years, 5 years later, and the person didn't get an updated copy, we're really confusing matters at that point. So be very, very careful. Finally, it's not just the will, the POAs, the trust. You want to make sure that your executor has a list of your updated assets. I have a bank account at Citizens Bank. I've got a savings account at Ally Bank. I've got an IRA with Fidelity. Okay, there needs to be a list, and also a list of important contacts and any other important information. Let's say you've got a pet. Are there any allergies, certain food requirements? Is this pet need to go back to a certain person or organization if you die? All of these things need to be somewhere that the executor can easily find everything at once. The fireproof box is great. You can put all of that in one place. So that's a little bit about organization. As I said, the more organized you can be, the better off your state administration will go. The faster it will go, the smoother it will go. Well, but probate, Jeremy, probate, I got to avoid probate. Probate's this evil thing, right? Well, it is in some states, but probate is meant to actually protect you and your estate so that the beneficiaries get what they're supposed to get. And also that creditors do get paid. The government gets what it's supposed to get. I mean, you're taking care of all of these things that you've got to take care of. You can't get around creditors that come after your estate just because you have a trust in Pennsylvania. And the government, with inheritance taxes in Pennsylvania, a trust isn't going to save you from that either. So you're not helping yourself by avoiding probate in Pennsylvania, nor in a lot of other states. Pennsylvania, as I said, has a more informal process for probate. So we don't go to court like we would 40, 50 plus years ago. In other states like California and Florida, you still do. So probate can get more complicated in certain states. But in Pennsylvania, avoiding probate, like doing so much to avoid probate, doesn't really help you very, very much, especially when you use a trust. And remember, again, inheritance taxes are probably, if not the most costliest component of any estate administration. So when you say probate and, it's going to be some attorney getting 10% of my estate, first of all, that's incorrect. The attorney is never going to get 10% of your estate for doing some work with the executor. That would be robbery. The attorney should get paid according to the complexity of the task. It can be hourly or flat fee, but bottom line is it's not going to be some large percent of your estate. The inheritance tax is going to be what the large percentage of the estate is, what comes out of the estate, I should say. Probate fees themselves are in the hundreds of dollars range in different counties. So we're not talking about a lot of money to actually physically go and probate and start that all. It's a little bit of money. It's $500, it's $1,000, whatever it is, but that's what it is. It's not, $50,000 to probate your estate. I promise you that. What are the inheritance tax rates? I've teased a little bit. So in Pennsylvania, this is again specific to Pennsylvania only, and I mean a couple things by that. Pennsylvania, meaning that you reside in Pennsylvania upon your death and that your property is in Pennsylvania. I don't mean that it's where your heirs are. So if I own a house in Pennsylvania, then upon my death, if I leave it to my children and they live in California, they will still pay 4.5% of inheritance tax. You see that rate at the top, lineal descendants, basically my kids, my grandkids, 4.5%. It jumps up for our siblings to 12% and everybody else, which is a broad swath of people, nieces, nephews, cousins, friends, partners, boyfriends, girlfriends, whatever it may be, 15%. Ouch, ouch, ouch. I've got a 15% estate that I'm dealing with currently. Not fun. There's a lot of money that's going out for that tax bill, unfortunately. As I said earlier, the federal estate tax, it still exists, but very few people are affected by it. And with this new law, less and less, fewer and fewer people will continue to be affected by the federal estate tax. With the new big, beautiful bill, I love saying that, the BBB law, it extended that exemption from 14 million now to $15 million with an inflation adjustment annually. Gift tax. There is no gift tax. It's unless you're very wealthy. It's tied to that federal estate tax, by the way. There is no gift tax until you reach, again, that $15 million amount. You can gift $19,000 per person annually. That's called the annual exemption without even touching your lifetime exemption, that $15 million. So if I've got 10 people that I want to gift to, I can give $190,000 that year and not file any tax return and not pay a single dollar in gift tax. And the recipients of the gift also do not pay tax. They do not pay any tax. Okay. Capital gains tax. You have to be careful when you're giving or gifting a highly appreciated asset. Let's say you want to give your real estate for $1 to somebody. Let's say you want to give stock and you've held this asset for a long time and you're trying to, let's say, avoid inheritance tax. You may hurt yourself or your heirs because they may have capital gains taxes due. Now, there are exemptions for capital gains taxes, but only for certain reasons, and you can't take them but once every 5 years. So you have to be very careful about gifting highly appreciated assets like stock or real estate. When you die and you leave highly appreciated property to your heirs, they get what's called a step up in basis. They no longer have to worry about all of the gain that you had over all of your years. So if you held a property for 50 years and there was, let's say, $1 million gain on it, and if you sold it, there'd be a lot of tax. When they inherit it, yes, they'll pay inheritance tax, but they're not going to pay the capital gains tax. on what you incurred all those years. Income taxes, they are part of the picture here, mostly for retirement accounts. So when the withdrawal occurs, income taxes are due. That's why we love Roths, because when you withdraw from a Roth, there is no income tax. And so if you can convert or contribute or do both, you'll be better for it. Guys, this is the time to act. You don't want to wait. So again, 15 minutes. That's all I'm asking. You can take 15 minutes out of your day, ask me some questions, check in about your current plan. We're going to give you that link in a few minutes. There's no obligation once we talk. All right. I'm not a pushy person. I promise you. Let me finish off with holistic planning. I teased this throughout. I said, look, estate planning, it kind of encompasses all these other components. Estate planning is sort of amorphous. It's really planning for our future and planning for the next phase of our life and planning for our family and the future generations. And so it cannot be done in a vacuum. And what I see too often is, well, I've got my attorney and I've got my financial advisor, I've got my tax person, and I have my insurance agent, and none of them know each other, none of them talk to each other. What we do in my organization is make sure all of these puzzle pieces fit together. That's what we're good at. So we have the experience from myself as the estate planning attorney. We've got financial advisors, planners, we've got a Medicare specialist, we've got CPAs on call. We've got everything we need to help you right here. So when I say holistic planning, I'm saying you want to make sure all of the puzzle pieces fit together. So as I said, there's different ways to sort of interpret what holistic planning means. One interpretation is they're all puzzle pieces, and all the puzzle pieces have to fit together to make sure your plan worked. If it were up to me, I would say the estate is the biggest puzzle piece and everything kind of falls under it, but everything nonetheless is connected. Your estate plan, your income plan in retirement. How are you going to have enough income, guaranteed income in retirement? Will your investments be structured so that you're not taking too much risk in retirement, that you're preserving for yourself and for your heirs? Is your tax plan, again, the most done in the most tax efficient manner? And have you done your health care and long-term care planning? These are all questions and all components that really fit together. Let me see if I can get to the next slide here. There we go. So I have questions for you guys. I want to know, how are you going to keep up with all the new changes in the law? We just had a big, beautiful bill pass. And there's a lot of pages to that bill, folks, and there's a lot of changes in regards to taxes and Medicaid and other components that could affect you and your heirs in the future. Who's going to help you keep up with all of these changes now and in the years ahead? You really can't just rely on yourself. And then who is looking at, is there somebody on your team? Okay, do you have somebody on your team that's looking at all aspects of your planning and making sure that all puzzle pieces are fitting together? Probably not. So if you don't, talk to me. So what are some examples as we finish off of holistic planning? I gave you a few here, but again, Roth conversions, that's a biggie. It dovetails into estate planning, tax planning, investment planning, retirement planning. Roth conversion, it converges with all of those areas. Life insurance, long-term care, it converges with tax planning, estate planning, long-term care planning, and also retirement planning. So holistic planning can cover a great deal of questions. These are just a few examples of where holistic planning just is so important. You want to create a trust, but did you set it up properly, number one? And number two, did you properly designate beneficiaries to ensure those assets go into the trust? Did you retitle assets the right way, or did you do the retitling at all? Again, I could go on and on about holistic planning. And what I see is there's a lot of piecemeal planning and therefore a lot of failed plans because the planning is actually incomplete. Oh, we put this big, beautiful trust together. It's 200 pages. It's going to do everything for us, except, oops, we forgot to fund it. oops, we forgot to retitle these accounts, the beneficiaries to go to the trust. So we created this trust because we want to protect the beneficiaries, but our retirement accounts still say that the beneficiaries get those assets directly. Oops. So again, holistic planning, somebody on your team to look at all the pieces of the puzzle and make sure they're all fitting together. All right. So this cartoon here, the quote is, while yes, your will is beautifully written, I'm afraid a few of the estate laws may have changed since 1942. Again, folks, if you have a plan, not quite since 1942, but let's say from the 90s or early 2000s, and you haven't thought about it or updated it, great, you're here. I love that. I'm so glad that you came on this webinar. Take some action. That plan that you wrote 20 years ago, 30 years ago, it's no longer a plan that's going to work for you. I can promise you that. Everybody's gotten older. Things have changed in your life. Your perspective has changed. The laws have changed. All right. So you made it this far. I've told you what the next step is, but again, I'll say it again. What's the next step? Talk to me. If not me, talk to somebody else. It doesn't have to be me. If you wanted to get some information today and then go on your merry way. Great. I would implore you to work with somebody that will help you look at all of these pieces of your puzzle, whether it's me or somebody else. I'm offering you the 15-minute intro call so you can talk to me one-on-one, get to know me a little bit, me get to know you, see if we're fit to work together. And if not, I'll thank you for the time and we'll go on our merry way. But if I can help you, all the better. So there's no pressure, there's no commitment. There's no fee. We're going to put that link. It is already in the chat, thanks to my colleague Nick. And with that, I know there were a few questions. If you haven't written your question yet, there's still a couple minutes to do that while we answer a couple here. If you have more questions, again, schedule the call. And you can also reach out to us via email. So the email is right on that page here, team@wechslerestatesolutions.com. Again, team@wechslerestatesolutions.com. And again, we put the Calendly link to go right on my calendar, right in that chat. So with that, we will take a few questions.
Yeah, I'm going to give you a chance to catch your breath, and
Yes.
I'm going to get in here
Love
with some
that.
questions that came through. Are there any exclusions from the PA inheritance tax?
So not many. It's a good question, but most of your estate will be taxed. So whether it's retirement assets, real estate, bank accounts, they will all be taxed. What's not taxed is life insurance. So that's a biggie. There's also some agricultural interests that you may have. Most of us will not have that, that may not be taxed. And also, if you leave property, if you're young, and let's say you have young children and you die very early, your young children will not be taxed. So there are different kind of carve outs that don't apply to most people. If you have joint property, jointly held property, then your, let's say you own it with another person, it's 50-50, your 50% will be taxed, not all of it when it passes on to the other person or other people. So that reduces the taxes. Just be careful about joint property. A lot of folks do it to sort of minimize taxes, but they create other problems. So talk to me or somebody else before you make property joint casually.
So, transitioning from that one, what should I expect to pay roughly to put a home in a trust for kids? And just about the role of trusts in general in PA.
Yeah, I would say when you're doing a living trust, again, as there's a slide that we'll send you guys, it's in this presentation from earlier, but a living trust will cost anywhere from $3,000 to $10,000 or more. It just depends on the complexity of the trust that you're building and why you're building it. So, it's something we can talk more one-on-one about, whether you even need a trust or not. Certainly things like a trust for Medicaid, which I kind of teased a little bit, I didn't get much into today, but like a Medicaid trust may cost several $1,000s as well. There's a lot of work and effort that gets put into making that happen. So it really varies greatly when you get into trust planning. I can tell you when you do a plan without a trust, so let's say you've got a will, power of attorney, whatnot, then you're probably under $2,000, if not less. It just depends on the complexity again.
Think that covers the big ones. Someone asked if this webinar will be available later, and yes, we're going to email out all the links and things with a copy of the video, a copy of the slides, and the deliverables, the rewards you guys get for sitting through this webinar that I'll pop up in the chat link here.
Hopefully it
Um,
wasn't too laborious to sit through. Thank you
um,
guys so much.
that
And
is it for the questions.
any more questions? No? Going once, going twice. If you have any more, schedule that time with me, guys and gals. There is the Calendly link that is available on the chat, and we'll also email it out to you. Thank you so much for joining me. I hope you got something out of this today, and I wish you the best. Take care.